Hi there all, I'm June Kales. I'm here in Los Angeles. I'm the moderator today, and the name of the panel is called Effective Legal Advocacy to Address Systemic Failures in Emergency Preparedness. And I would add to the title, Having Realistic Expectations. So because of the richness of this panel's experience and our limited time, we'll try and get to a few questions, but I know that DRNY will post in chat how you can contact them if we do not get to all your questions today. So bear with us on the question front. I, as your panel moderator, am I'm the only non-lawyer among us. So have patience, but however, my questions stem from years of experience working as what the lawyers like to call a subject matter expert. And I worked with the Department of Justice and a variety of public interest and private law firms on disability civil rights cases related to emergency services and healthcare. On the disaster side, I worked on cases related to LA City, LA County, Oakland, California, New York City, and some international airport issues in the United States. So I've been around long enough to have the long view, which includes identifying and dealing with my own magical thinking regarding legal activities in terms of what we can accomplish and really what happens when the judge and the lawyers stop paying attention and the monitoring and the reporting stops. So myself and other disability advocates often say, let's just sue them. Let's just sue them, without maybe knowing or acknowledging the time and effort this takes, the pros and the cons. So panel, let's look at some of the realities regarding these legal activities. So panel members will have up to 5 minutes to answer each question. And I may modify the questions a little bit as the panel progresses. So the first question, and I'll call on each of you separately, you'll have 5 minutes. Briefly introduce yourselves, and then give an example of your involvement in an emergency case. Describe the time frame, monitoring, and impacts and outcomes. So Linda, you're it. We're going to start with you.
Great. Thanks so much, June. I am Linda Anderson Stanley. Thanks for having me here today. I am the Associate Director for Disaster Programming at Equal Justice Works, where I supervise and oversee our disaster resilience program that mobilizes attorneys across the country to help individuals respond to and prepare for disasters. I also teach a disaster law primer at Stetson University College of Law, and am involved in the American Bar Association's disaster programming as well. And so I chose a case to discuss with all of you that is not an actual lawsuit, but a route that lawyers can take that does not require suing somebody, as June alluded to. So this particular client was an individual living with a disability, a senior, a widower, and a veteran. His only source of income was $1,100 monthly from Social Security. He had no homeowners insurance and no veterans benefits. He lived in Florida and sustained serious damage to his home after Hurricane Irma. large portions of his roof were ripped off of the home during the storm, so exposing the house to rain during the storm, and then of course subsequent storms as well. Because of that, water leaked in, causing the ceiling above his bed to collapse, leaving a huge hole behind. His heating and air conditioning units were destroyed. And then because of the AC being out, the place just was covered in mold and getting worse and worse. Because he required accommodations and due to his very limited income, he was unable to leave and frankly afraid to leave his home. So he was forced to live in these conditions. Hurricane Irma made landfall in Florida on September 10th. And so days after that, he properly applied for FEMA assistance. On October 16th, at FEMA's instructions, he also applied for a Small Business Administration disaster loan. On October 18th, 2 days later, he was denied that SBA loan due to a lack of ability to repay the loan. On November 2nd, a FEMA inspector came to the client's home to inspect his damage. The inspector inspected the interior of the client's home, but per FEMA protocol, they never inspected the roof. FEMA inspectors will not go onto the roof of an applicant's home. The client, physically unable to get onto the roof himself, had no proof of the roof damage, no photos, and likely at that point didn't fully understand the extent of the damages himself. A few days after, he received a denial letter from FEMA, which was dated November 2nd, the same day as his home inspection, denying him FEMA home repair assistance. The letter stated he was denied because his home was deemed safe to occupy by FEMA. So after 2 months of living in mold with no air conditioning and advocating for himself, he thought he had no further recourse until he heard of legal services. So the client came to my office in December, explained his situation, and within a few weeks, I was able to work with him to get estimates for repairs for his roof. We also worked with his son to get up on the roof for him and take some photos of the damage, which were extensive. There were huge chunks missing from the roof, large gaps, shingles missing. His son was also able to help him tarp off the roof in the meantime to avoid further rain getting in. So by December 29th, I submitted an appeal to FEMA on my client's behalf, explaining the extent of the damages and showing it would cost him over $7,000 to repair the roof. On February 14th, about a month and a half later, the client received a check for $3,000. He was really excited to have some relief, but disappointed knowing that this would not cover the repair for his roof. He assumed this was the end of the road for him. Knowing the extent of damages he sustained and the fact that he has no homeowner's insurance, I decided to appeal FEMA again. So we wrote another letter asking for additional funding, stating that this was not enough to repair his roof. And shortly after, he received another check for $5,000. So besides those 2 lengthy appeal letters, there were many monitoring calls to FEMA on the client's behalf in the meantime. All of these things were such a heavy burden on him, things such as printing color photos, mailing letters, making phone calls. These are something I could do easily on his behalf, and having a lawyer intervene clearly changed his outcome from $0 to repair his home to $8,000 to have a brand new roof to withstand the next hurricane. So this is an example of a non-litigation case that had a huge impact on the life of this client and his recovery.
Wow. Take your breath away listening to this, Linda. Thanks. Next, Ariadna, you're on.
Yeah, of course. First of all, I'm incredibly grateful to be here again. I was able to join the previous panel, so it's good to be back, virtually back in this space. So I have been working with Ayuda Legal Puerto Rico for 8 years now. We're basically an organization in the ground in Puerto Rico that does work regarding legal empowerment, access to justice. But since 2017, when Hurricane Maria hit the island, a catastrophic major hurricane that basically destroyed a huge part of the housing stock in Puerto Rico, that we became disaster legal aid responders. So since then, we have had 6 years of continuous disasters, earthquakes, hurricanes, floods. And I couldn't do more than agree that the just sue them attitude is not always like in the best benefit of the survivors. And that oftentimes when we as lawyers are thinking about the courts and we're thinking about the administrative proceedings so that people can, for example, appeal FEMA assistance denials, oftentimes that is not the best options for people who will be lost in a process that is highly complicated and that is highly discriminatory for people with special characteristics as it would be the disabled population. We think that because the recovery system is broken, then this process, the administrative and the judicial arenas are also broken. So we need to find other ways to highlight the work that we have been doing. And I wanted just like to mention briefly a case that we have had for almost 5 years now. And this is the case of Marianne. Marianne is a single mother. She has a disability. She is a single mother. She has 2 kids. Both kids are special education students. And Marianne went through the whole ordeal of people like trying to request assistance after a disaster. Marianne requested assistance from FEMA, and FEMA denied based on the fact that she had insufficient damages, even when her house was basically shattered completely. Afterwards, she applied for another program, a FEMA STEP program, and she was again denied because the damages were so huge and monumental that the assistance that could be channeled throughout the program would never be sufficient for her to have a safe housing. Then CDBG-DR funds came in a couple of years after Maria, and she was one of the first applicants using Windows for people with disabilities. And after she went into the program, she was not denied, but her applications was stopped or blocked because she lacked a formal title. She was an owner who lacked a legal document to prove her ownership. And while we were working with this case, with litigation and with advocacy and going to the Congress and going to the local legislature to speak about barriers for people with disabilities within CDBG-DR and long-term recovery processes, I remember all of the things that Marianne had to go through just to be able to get her house. The way that, for example, temporary shelter assistance was not in place for people who were like requesting CDBG-DR funds, the way that temporary rental assistance was not in place. So she had to get another work and having mobility issues that truly meant that then she could not like met the demands of her 2 kids. And then having to move the kids, but in a place where schools are being shut down because of budget cuts. She had no options for the kids to be able to get their therapy and the medical attention they needed, and how she was like couch surfing with her family for 1-2 years, and then the impact on her mental health that the whole non-recovery process had. So I think about cases as Marianne, and I think about how it is very hard for low-income survivors, but when that survivor has special characteristics like being a disabled person, that means that it's almost impossible for them to be able to guarantee just recovery. So our work is to understand as lawyers that our legal tools are not enough to bring that change to the table, and that's why we do advocacy work.
Okay, thank you. And Mark, you're last for this question.
Yes, thank you so much, June. My name is Mark Fleetner. I'm a director at Disability Rights New York, which happens to be the host of today's event. We're so glad we're all gathered here. DRNY, as we're referring to ourselves, is the Protection and Advocacy System, providing legal advocacy for people with all disabilities for the state of New York. Each state and each part of the country has their own, so that's something that folks should consider a resource. I'm going to tell a different version. I'm going to tell a litigation success story for you all. I did want to note before I do that I am a white male, gray hair and beard, dark blue shirt, and I'm sitting in front of some family photos that are on the shelf behind me. We initiated quickly for obvious reasons, and this would have been in April of 2020. So if you all can take us back to April 2020 in relation to the COVID-19 pandemic, it was a very, very difficult time, particularly for New York State and particularly in New York City. I'm sitting in Brooklyn as we speak. So that then Governor Andrew Cuomo, on an emergent basis, began to hold televised press conferences every single day, set time, things like that. And so, of course, our concern was that these were accessible to everyone because the nature of the information that was being provided, reports from the Department of Health, reports from rangers that we're helping with, all of these different things were critical to everybody's safety and well-being. And we heard from some colleagues of ours at the Harlem Independent Living Center and some other advocacy groups for people with disabilities that they were unable to get the information because Governor Cuomo and his staff were not providing a live ASL interpreter, as you all see with us today. We tried not to sue. We started hearing the stories of folks about how that was of great concern to them. We also recognized that it was an economic justice issue because a lot of the people who do not have access to laptops and the internet would not be able to access some interpretation that the governor did in fact have if you tune to the right website. But folks began to explain to us, they're going to a neighbor's home, they're watching a good old-fashioned television, and the information is critical. So we gathered the stories, we explained it, and they didn't get it. They said, we don't understand. All you got to do is click on the right button on your laptop. And again, some of these disconnects made it clear, and they ultimately said to us, nothing's going to change. So we did immediately file a federal action charging violations of the Americans with Disabilities Act and Section 504 of the Rehabilitation Act to say that emergency services must be accessible to everyone. And what could be a more important emergency service in that moment in time than getting the day-to-day information about what's going on? So and of course, with that, because every day mattered, we sought a preliminary injunction, and we, asked for a quick hearing of our basic premise by a judge in the Southern District of New York, and we did prevail. The judge understood and did say, and it was important case law for us lawyers, that the ADA does in fact guarantee this under such circumstances. Live ASL interpretation, so if it's a televised press conference, everybody who tunes in or listens to an audio of it or whatever can access it. I think as I talk about this case, particularly about the circumstances of a man named Mr. Nguyen, who was the only language that he understands is ASL. His country of origin was Vietnam, but he'd never learned to read or write in any dialect there or in English. And he was not somebody who had access to the internet or a laptop. And yet he needed to go out every day to work at frankly, the Home Depot and help customers who were trying to get things to protect themselves and all of that. And he needed to know what the conditions were to keep himself safe, masking, all of the different things we were talking about. And I think those were the kinds of narratives that the judge understood. And then, perhaps unsurprisingly, once the judge made this finding, we were able to settle the matter, and the live ASL interpretation was there going forward. This is not always the case. And there are some impediments to federal litigation, which we maybe will have a chance to talk about in the context of public health emergencies or weather emergencies as we go on. But that was a success story that that we were proud of. And then we began looking at other things we could address through COVID, some of them with less litigation success. So I'll leave it at that for now, June.
Mark, just one fact, how long did that take to resolve?
That was a matter of days. Because we had made it clear, you know, that the judge put the oral argument on quickly, and we all gathered, and she heard the arguments, and she made a decision, and it was a written decision. And then at that point, it was clear that they were required to keep it in that moment in time. And she said, you have to until we can resolve this. And then it was clear that they had found a way to do it. It was not particularly onerous. It was just a matter of understanding the accessibility components. And we were able to formally settle it for the long haul. I will say we monitored it. And there were days when there were some things that were off about the placement of the ASL interpreter. And we called the lawyer in the other case and made sure that our objectives were in fact being met going forward.
Thank you. All right, well, continuing on what you laid out for us, all of you, from an advocacy lens, given the case you just reviewed, tell us what worked and what didn't work and what lessons can be applied. And I'll add for Linda and Ariadna regarding Marion, and Linda, the gentleman that you described. How did your significant and substantial intervention help with some of the systemic fixes that represented what was wrong? So we'll start with Ariadna.
Okay. First of all, I thank you, June. I think that disaster assistance should be designed in a way where lawyers are not needed for people just to be able to access immediate assistance, like a shelter or like housing or like rental assistance or personal property replacement. And I think that the need for disaster legal aid or disaster legal work speaks a lot about how inaccessible this process is. There's a community leader that told me a couple of years ago that she felt that disaster assistance was like a lottery, and that she was playing year by year to see if any other day she would actually win the jackpot and have her house repaired. And in that sense of it being a lottery, or if maybe it will happen, there's a lot of time that is lost. There is a lot of hopelessness. There is a lot of re-victimization of the survivors. And the idea that disaster assistance is charity ends up being very widespread, that some people get it, some people don't, but it's okay because anyways, you did not deserve it or did not have a right for it in the first place. So I will say, about what has worked, what has not worked. What has not worked for us, asking the government for more precise statistics about the people who were left behind, those FOIA complaints or access to information complaints, those efforts for them to clear up the statistics and just to be able to develop a more concrete standpoint based on data about who was being left behind in the aftermath of disasters. That was not a very good statistic. That's good for reports. That's something good that you want to put out later on in reports, but you don't actually need that to be able to do the work and advocate for more inclusivity, because the access to information piece is like a vicious cycle. It's something that it's that is never cleared up, and that is something that maybe we should talk about later with a cup of coffee in our hands. The things that did work. For us, storytelling pieces work. I remember recording the testimony of Marian. We made a storytelling piece in video. We media trained her, and we went out just everywhere where we could like have a forum, like national news, newspapers, radio. And her story became the story of so many others like her because she was really relatable. I think that although it may look, it may sound like a contradiction, like putting out our own data pieces was good because we are a non-LSC, Ayuda Legal Puerto Rico, and never receives or request any government from any funding from the government. We started like having a whole lot of like mechanisms like advocacy workshops, advocacy meetings, community assemblies to raise our own data about who was being deeply affected by inequality in disaster assistance, and that was very useful for us. And also the fact that we started like asking for congressional hearings, asking for hearings with the fair housing fair housing offices elsewhere. And that was very useful. And for us, it also worked like the power of coalition building. We knew from the beginning that we couldn't do this alone. In 2017, we knew nothing about CDBG-DR funding. And I think that coalition building with people from Texas, from New Jersey, from New York was essential. Louisiana was essential for us just to be able to join a narrative of inclusivity in regards of disabled populations with disasters.
Well, thanks. Important point about chasing data down from the government. We could go into that for a long time. So thank you. Let's see, next, Linda.
Sure, thanks, June. So I chose the case that I chose to highlight because it's truly not an uncommon scenario. When FEMA comes to inspect your home after you've applied for benefits, they ask if you're willing to relocate. In this case, the client was unable to relocate due to his disability and his lack of income. So of course he said no. And this is a very common and very reasonable response from low-income FEMA applicants and those individuals living with disabilities who have specific accommodation needs. Unfortunately, we've seen time and time again that FEMA then assumes this means the home must be habitable and safe to occupy. Otherwise, he would just be living somewhere else until repairs can be made. But as we've seen, given this response to FEMA almost always results in a denial of benefits. It's like a check mark that they fill out on their side. And as you saw in my case, he immediately, same day, received a denial. Unfortunately, I don't think that this particular case changed this systemic issue here, but the knowledge about this trickiness of this question is becoming more and more widespread. And through my work with the American Bar Association, I do have the ability to work with FEMA and uplift these types of issues to their attention and hopefully talk to folks about not asking this in such a way that basically tricks applicants into saying, no, they're not willing to leave. And I think it's such an important area for legal intervention. As I kind of laid out earlier, it doesn't really take up an absorbent amount of attorney time, and it works. We can advise the client of how to respond to this question during a FEMA inspection. And we could also effectively make an argument on the client's behalf in the FEMA appeal, including these types of intricacies that most people just don't know that they need to explain.
Oh, Linda, having been in the lane of working with FEMA to try and change some of this process that the inspectors use, have you considered or did you consider filing a parallel complaint with FEMA Civil Rights Office?
So in the capacity that I serve now, I no longer provide direct legal services. So I am not actively practicing law, but the program that I supervise, our fellow attorneys are always looking into this as different options. And because I work so closely with FEMA, it was kind of a conflict of interest to be able to file something that like that at the time. And we kind of try to, again, as we talked about before, use these alternative methods to filing claims. So meeting with them quarterly and having these conversations and getting to headquarters or to the inspection folks or to the housing folks and trying to raise these issues or having conversations with their general counsel as well. It has worked in some instances. For example, we spent a lot of time talking about the issues with folks who do not have clear title to their home, and that differs depending on what state you're in or what territory that you're in, and that looks different depending on your culture, and that we can't just have a one-size-fits-all response to that. And due to a lot of our advocacy within the American Bar Association, now there are changes in FEMA. So it does work. It just kind of takes some time.
Yeah, thank you. I do worry about the hundreds of people like the gentleman you talked about where there's assumption if you're living there, it must be okay.
Right.
And without any recognition of what's going on. So maybe we can circle back to that again and how that gets dealt with. Mark, I think you're it.
Sure. So as I probably alluded to, much like Ariadna said, narrative storytelling works because we looked for plaintiffs whose stories were particularly compelling. Each case gets assigned a name, so-and-so versus, Cuomo. And in this case, it was Martinez. And Mr. Martinez was the person who was the deaf coordinator for this Harlem Independent Living Center and started to get all the scared calls from folks and is a deaf person himself. And when the judge heard those narratives, that really turned it around for the judge. So I think that's really important. And I love the creativity of using the media in different ways that we can now in order to do that. What didn't work, and I'd love to pick on something that one of my colleagues referenced, and actually we're all talking about data. You have to talk about data as lawyers and those that are appealing to policymakers, because every budgetary responsibility has to be predicated on data that shows it's the case. When we reached out to government entities, even in our unique position as the protection and advocacy system, that is state government entities, they were not forthcoming with data. There was a protectiveness about it, and the reality is, and that's why these conversations are so important after emergencies, is that there really wasn't good data being kept at that point in time. So there's this huge lag in time between the time that somebody starts to get around to keeping data. Is it still accurate if you wait too long? That's a question too. And then to the point where it's codified in a way that a policymaker can take it to the state, lawmakers or the federal lawmakers. I think that these conversations and these connections are really important, particularly with this issue, as opposed to going right for litigation, because we are all, the reason why we're all able to weigh in with these narratives from across the nation is because we're all being impacted by weather emergencies and public health emergencies. We know we will be more, and there's such a commonality with what our obstacles are. And the other thing that's so critical to it, I think my colleagues would agree, that it's all about advocating for federal, state, and local connections and collaboration, both budgetarily and from a planning perspective. But as you know, our position is we cannot doing it. We cannot engage in it. Nobody can be engaging in it without people with disabilities who lived it and know the issues at the table for every critical conversation.
Well, maybe we can do another panel on chasing the data. But Mark, in the meantime, you did mention, of course, there will be slips when there's no interpreter, and there needs to be, and you said you called the lawyer, and okay. So what's that lesson when that lawyer is no longer there, or who do you call and remind them of this case? What's the protocol here?
Thank you for that question. As I indicated, the mayor's office agreed to continue this for the duration of the COVID-19 press conferences via a settlement, a worded settlement. And very often, as colleagues and many of those on the call know, when a case is settled that's looking for systemic change, there is a really concrete monitoring piece that's built into it. Okay, you've settled it, but we're not going away because some entity or some individuals are going to check on your compliance going forward. With the ASL, that was resolved when the press conferences stopped. But for example, in other cases that we have, it requires that there be eyes on certain facilities and whether they're complying with safety measures, things like that, accessibility, evacuation procedures, all of these different things. And the reality is, I have found, as somebody who came to this work from criminal and civil rights, different kind of civil rights law, and I'm looking at cases that preceded ours, that once staffing changes and once things change, there is a lack of accountability for the entity that promised to do these things. And there's also, and this is something that we're all facing now, cries of, we can't afford it, we're understaffed, we're doing the best we can, but the world has changed since you settled this. And so it is so important that the settlements be as explicit as possible and as comprehensive as possible. And it's also critical that someone at the organization that was responsible for achieving the settlement continues to be the watchdog to make sure that the monitoring and all of the things, the checks and balances are carefully watched, even when new generations come up and have to address the case.
Thanks, Mark. All good points. So this next question kind of blends into what a lot of you have already been talking about. So this gives you an opportunity to really expand on some of what you said. And that is discuss other, maybe quicker, although questionable, effective and efficient legal tactics that are alternatives to lawsuits. No, and you've already brought up, maybe you want to go a little bit deeper with data, with storytelling, with using the media, with coalition building. So talk watchdogging. So talk about this in terms of not just the tactic, but also tell us about what did the tactic yield in terms of an outcome or an impact. So let's see, this time we go with, I guess, Mark, you're first this time.
Well, I think in this context, I'd like to turn to a case that great advocacy colleagues at a court, at an ILC, a Brooklyn Independent Living Center, engaged with, along with another great advocacy group, Sydney, and individual plaintiffs well over a decade ago. A great trial took place really exactly a decade ago, 2013, early 2013. And what happened was these entities had sued, again, New York City happens to be where I'm sitting, and said that the emergency procedures that were in place at that point they absolutely, for a lot of different specific reasons, were not accessible, were not safe, were not appropriate for folks with disabilities. And after a lengthy trial, again, in and around March of 2013, the judge put out a brilliant decision that acknowledged that the ADA and the Rehab Act require certain things. They require accessibility in evacuation procedures. They require that the evacuation space be accessible, right? Things that are obvious to maybe some of us on the call, but doggedly are difficult, are difficult to explain to those who are sometimes, the policymakers. And I have spoken with folks there about once the trial was determined, yes, you got to do this, then it was down to discussion and agreements about how that would take place. And the reality is the current leadership of that independent living center, was frank with me that there are frustrations with what the state has and hasn't done, what the city in that case has and hasn't done. Let's remember, it's a city. How many times has it changed administrations in the years, right, since that happened? But the law is there. the law is there, and the law is there to be used. The actual written decision and the language is there for us to be used. So part of what we need to do as advocacy groups, legal oriented advocacy groups, is make sure we're all up to speed on what the current state of the law is in terms of protections for people with disabilities in emergency preparedness and management. That's part of why we wanted to get together today, but I've come to the conclusion that it's always a synthesis of advocacy approaches. Yes, you can sue. Yes, you can sue to enforce a law that was already in existence, whether it be a local law or the ADA, but there also has to be a groundswell. There has to be a somewhat, for good, orchestrated groundswell between, all of those people who understand that this is such a critical human rights issue. And that, along with getting some interesting journalists, journalism isn't what it used to be. There's a lot of great work being done online that can get just as much attention as, the evening news, the good old fashioned evening news on three networks. Being creative on how the stories are told, and then pushing for the money to be spent and the commitment to be made to get the data, to analyze the data, to sit down and process, and what my colleague referred to as a postmortem for each and every, because think of all the things that the judge in that case a decade ago could not have anticipated that we in this room have learned, just, for example, with the pandemic, and how many things wouldn't have been addressed unless we stop now, look at it, and keep learning.
Mark, it's hard to believe that was 10 years ago. As somebody who is intimately involved with the entire process, I want to just draw upon one lesson for me, which is that those independent living centers spent 3 to 4 years prepping before it ever went to trial. And here we are 10 years out after the trial, and the monitoring and the meetings, that has to continue. So when you dive in, this is almost a lifetime commitment. This kind of a Herculean effort. It's not over after the judge issued his 187-page opinion. So thank you. Ariana?
Yeah, listening to Mark and thinking about some of the things that we have pushed forward, besides, using like different outlets, and also understanding that the power that litigation has may be useful at some points, but it's not always the most successful or quicker or quick alternative for people. For us, I would add that community brigades and community Know Your Right workshops have also been very useful to push not only for a legal solution, but to push for narrative changes. So the fact that we're talking about recuperación justa, or just recovery in Puerto Rico, that we're talking about, more equity in the distribution of disaster assistance, I must say. I think that pushing for those narrative changes, speaking with the people directly, and having the media and having the government know that you're doing that has been very useful for us. Oftentimes, we use a lot of fair housing litigation in our office, and before filing a complaint, we usually make a happening about what's going on, and we talk about the possibility of filing a complaint. And oftentimes that's the moment where the actors who are responsible for the violations, the corporation behind a low-income housing tax credit project, or a PHA, or the local government distributing assistance, they end up answering because they don't want that bad media coverage. So for us, that has been very useful, using, for example, the complaint process of FHEO. It's of course it's good to file a complaint to be able to get a voluntary conciliation agreement, to finally have some changes to policies. That's amazing. But if we could save survivors, specifically people with disabilities, you know, the process of having to go through a legal process to be able to demand what was theirs in the first place, we could do that with a legal empowerment perspective. And for us, you know, that piece that has to do with legal empowerment, with community brigades, with community workshops, has been highly and incredibly useful. We have been able, for example, to change many of the guidelines that were obstacles for survivors within CDBG-DR in Puerto Rico. We were able to push with others advocacy so that people with informal titles could be able to access assistance from FEMA in a more streamlined manner. So we have been able to have wins, but that wins, usually the law is just like part of the tools. It's only one more tool that we use to be able to get this change. We need a lot of tools. You know, we have people who work with social media, and that's the tool that you bring to the table. My tool, as a fellow and as part of that movement to transform and make it more equitable, is law. And we each like need to know the right size of our of the tools that we have. You know, that we are not as powerful as we were made to believe during law school, and that we as are part of an ecosystem that needs to be committed with sharing the spotlight oftentimes to be able to win.
Oh, good points. I like starting the process could actually initiate a change or a win. You know, I always think about throwing a stone in the water and hoping for the ripple effect throughout everywhere. And that's another one of my magical thinking dreams, but I'm not going to let go of it. So, Linda, you're last.
Yeah, thanks, June. Definitely agree with everything my colleagues have said here, and not too much to add, but just to kind of tie it all up, I think that legal aid or free legal services is such an important piece of emergency and disaster response and preparedness. I know typically folks don't immediately think of us when disasters strike, but there are just so many roles for lawyers to play in preparing communities for disaster, helping them equitably recover from disasters, and building resiliency in the future. And while filing a lawsuit is sometimes the best route to take, most of the ways in which lawyers empower disaster survivors are by doing things that don't involve lengthy lawsuits. I think we've already touched on that a lot today, and also that many legal aid offices providing these free services for disaster survivors don't always have the financial and capacity resources to provide these long, lengthy trials. But lawyers can still help prepare communities for disasters by providing those educational and outreach events to help folks understand their legal rights in the aftermath of a disaster, like Ariadna just mentioned. They can review insurance documents and leases and property deeds to ensure that people are prepared for disasters, or take necessary legal actions to help clear title to the property or help securing immigration status before a disaster strikes. They can provide trainings to ensure local shelters are equitably accessible and safe for domestic violence survivors. Of course, they would spend time creating these connections and networks within the community, as all of the panelists have both mentioned today. And in the aftermath of a disaster, attorneys can assist with FEMA and other public benefits, avoiding illegal evictions, insurance scams, wage theft, issues with guardianship, and the list goes on, of course. But in most of these cases, like the FEMA appeal case I described earlier, just a letter from an attorney can go a long way in getting an insurance company to pay out or stopping a landlord from filing a frivolous eviction without ever stepping into a courtroom.
You know, that I'm still thinking about that gentleman you talked about more than a half hour ago, and I'm thinking about all the people like him. Do you have any view that assumption of livability of a place has been modified in terms of the way inspectors think about this and judge it?
So the tricky thing that I have learned is that FEMA does not really define what they mean by habitable. And they also do not publicly share what the inspectors use to determine habitability. So that has been something we have been asking for and doing FOIA requests for and talking to FEMA for years, but it just doesn't exist. They don't share it. And I think that's part of the problem is we've been trying to get them to put something together that the public can see. What is it that these inspectors are going in there and being told? What standard are they using? And we just don't know is the answer right now.
Seems like something that critically important should be a policy and a procedure and very clearly defined, or at least some margins of definition. Just my editorial comment. Couldn't resist. So let's see, we have about, I think we have about 9 minutes left. Any last thoughts from any of you, things you wanted to get to but couldn't? I will say I'm struck by, you know, what an important discussion this is. And I, as a chronic question asker, could ask you all, you know, many more questions about what you said in terms of this rich and thoughtful discussion. I think we need a semester to, you know, dig at and unpeel all of these layers. There's so much here that, well, I'd like to spend more time on. But how about the three of you? What are your last words?
One thought I want to put out there in the broad conversation about advocacy on emergency preparedness, who needs to be at the table, how we need to inform ourselves. The reality is that litigation, suing, a lot of our legal remedies, they're reactive. They are inherently reactive as opposed to proactive. So that I feel like advocacy movements in this space and many others that impact on people with disabilities have to be about community education, judiciary education. You know, we didn't succeed with the COVID-19 case because we were saying that there were some guidelines that New York State had via the Department of Health that would have allowed personal ventilators to be taking care of folks who are entering an acute care facility. And the way we got to court was by saying that this is an extraordinary harm to get somebody so afraid that their ventilator was going to be taken away from them and reallocated, their life support by, you know, literally, that they were not going to get treatment for COVID. We brought that not only to court, but to the appellate court. And ultimately, the appellate court said, well, that's not really a harm. We didn't need to ration ventilators. So it's not there. And so it's this cultural, you know, perspective that does impact on the judges that make these decisions as well, and policymakers, that we need to get more adept at. And because for those of us who had fought the case, the idea that that would not be a harmful position to be in under such circumstances was kind of unfathomable to us.
So, Mark, a great point about legal remedies are reactive instead of proactive. I think that's a great point. But I wanted to just comment early on. You said that the suit about the interpreter, that the decision was that would be in place throughout the COVID emergency. But this is much bigger than the COVID emergency. This is about equally effective communication. And why was that tacked on to the decision as long as the COVID emergency? Why?
Well, it was based on the fact that the claim that we brought was that particular activity of having, you know, so that, look, but that's what we lawyers try and do. And that's where the good news can be, is that case law, you know, things that the judge said in granting our preliminary injunction can be used by other lawyers and used by other advocates, like the case that I talked about, which is, by the way, BCID versus Bloomberg, because some folks I think were asking. we have to get good at using those, but that's a fair question. And when they had a subsequent press conference about something else, it frustrated us. It's just that we knew that that was the basis for the complaints that folks had made to us.
Okay, so building on case law and within the limits. Okay, so Linda and Ariana, you both have about 2.5 minutes for the great last words.
Thank you so much. First of all, I wanted to say that I'm incredibly grateful to be here, and I know that it's at 2 minutes like early, but I truly need to hop off because we have like a huge lobbying win that's incoming today. We're about to make a domestic violence, like to include economic violence as a way of gender violence in Puerto Rico. And that's a huge thing for us. And we just received the message from the legislators and they're about to push it to the floor. But besides that, I wanted to say, that for us, it has been useful like to create a community paralegal project amidst the disasters. And the idea has been for people to be able to obtain the legal knowledge and to have in their hands the legal tools so that they can design their own strategies to obtain not only disaster legal aid, but also to obtain affordable housing, fair housing after a disaster strikes. The Community Paralegal Project, which is based on international efforts, to socialize legal tools and to socialize legal knowledge, has been like able to get important things for their community. Right now, they're located in a specific community in Puerto Rico. But most of all, it also challenges the idea that we discussed like briefly at the beginning, that people should not need a lawyer to do many of the things that they do. And that also has to do with fighting unauthorized practice of law, unauthorized practice of law rules that basically criminalize or sanction people, normal people, civil people, just for exercising or using the legal mechanisms that are available and that oftentimes decide over their lives. And I think that we need more programs like that for people with disabilities, for elders, for women, for Black communities, so that we as lawyers we don't are like the gatekeepers of the knowledge and processes that have to do with recovery. I truly need to hop off, and I know that's very bad, but I really wanted to thank just like for the chance of being here.
Excellent points, and good luck with your next advocacy endeavor in a few minutes. Good luck with that. Linda?
Yes, thank you so much. I just want to really quickly bring us back to the proactive versus reactive structure, which I think is where a lot of us live in this disaster world, is in the reactive. But a lot of what I do is trying to educate donors specifically about the importance of being proactive and assisting folks in the preparedness phase, because that's how we can truly build resiliency when we are not in the middle of crisis working on these issues. And I think it's just so important for the folks who have the funding to put disaster legal aid attorneys or assist with all the other types of organizations who are responding to disasters, to empower folks to be able to assist in blue sky times and to create all of this change that we're talking about today, and ultimately really build more resilient communities. So as much as you all can, I would love for everybody to take away from this to advocate for being more proactive than reactive in this space.
Excellent point. And for me, your message is, I will call you when the sun is out for assistance and help with our tactics and strategies, because you've got y'all have a wealth of skill sets and knowledge that can help us to be more proactive, but tactical. So we can really make that systemic change and impact we're looking for. So again, thank you all for a very rich and thoughtful discussion. In many ways, it was a tease to what should be a long playing movie, but thanks again. And back to you, Helen.
Yes, thank you. We'd like to thank each of our speakers, moderators, and for all of you who've joined us today. If you have questions or questions that we weren't able to answer live, please email emergencypreparedness@drny.org. The recording of this event will be made available on our YouTube channel within 2 to 4 weeks. Everyone have a great rest of your day, and we'll see you tomorrow.